I am Arunava Bayan from Pondicherry University, Department of Political Science. Today I am going to give a presentation on Directive Principles of State Policy in India. When the framers of the Indian Constitution constructed the draft of the Constitution, they also included some ideals called Directive Principles of State Policy in the Part 4, Article 36 to 51 of the Indian Constitution. In this regard, they were inspired by the Constitution of Irish Republic. We can locate the origin of these principles by looking back to the French Declaration of Rights of Man, American Declaration of Independence, the United Nations Charter, and the 19th century's liberal philosophy. Dr. B.R. Ambedkar viewed the directive principles as the novel features of our constitution. The governments, whether state or central, and local authorities are bounded by these fundamental principles for the administration and enacting laws for the country. The authorities of India have a moral commitment for applying these principles. Directive principles are parallel to the instrument of instruction identified in the Government of India in 1935. These principles present a perception of the subsequent period of our country. They act as the substitute for fundamental rights, while the fundamental rights try to create a division between the state and the citizens, but the directive principles try to create a link between them. They aim to formulate India as a democratic and modernized state through an all-inclusive social, economic and political curriculum. Accomplishment of some ethics of the preamble of our constitution like justice, liberty, equality, fraternity is the principal aim of directive principles. The idea of making India a welfare state was a utopia before the incorporation of directive principles in our constitution. Although these principles are not irrevocable in nature and are not being capable of enforced by the law courts, and their implementation heavily depends on our country's resources, they are of immense importance for the courts in investigating whether the laws made by the legislature are constitutionally valid or not. Directive principles contemplate that states should take necessary steps for the proper distribution of power in society, which ultimately would help in empowering the people of India. Although the directive principles are not distinguished in the Constitution, we can divide them into three broad groups: socialist principles, Gandhian principles, and liberal intellectual principles. Socialist principles firstly authorizes the state to secure a social order for the promotion of welfare of the people. It contains certain principles of policies to be followed by the state. It says about the equal right, justice and free legal aid. It talks about the rights to work, education and public assistance in some cases. It provides for just and humane conditions of work and maternity benefits. It provides for safeguards for living wages, adequate living standard and other opportunities for all workers. It ensures the participation of workers in the management of industries, and it talks about the duty of the state to raise the level of nutrition and living standard and to improve the public health. The Gandhian principles talks about the organization of village panchayats as self-governing units. It encourages the establishment of cottage industries in small and large scale. It talks about fostering societies in a cooperative basis. It advocates for the enlargement of educational economic interests of scheduled caste and scheduled tribes and other backward classes. It forbids the consumption of some drinks and drugs which are detrimental to health, and it puts a ban on killing of cows, clades, and it talks about the enhancing their breeds. The liberal intellectual principles firstly seeks to defend a uniform civil code for the whole India. It seeks to furnish early childhood care as well as education to those children who are below the age of 6. It provides for facilitating agricultural and animal husbandry in a proper sense. It talks about the protection and improving of environment and providing safeguarding of forest and welfare. It emphasizes the protection of monuments, places and other objects which carry significant importance. It provides for the division between the judiciary and executive of the state. It lastly talks about increasing international peace and security and improvement of relation between different nations. The directive principles carries an identical root with the fundamental rights, and therefore their motives in similar in nature, which was to constitute India as a welfare state as prescribed by the preamble of our constitution. Directive principles are different from fundamental rights in some cases, as directive principles are positive in nature and acts as some instructions, but fundamental rights are negative in nature. There is a firm treatment in case of violation of fundamental rights, but there is no such provision in case of directive principles. The law courts are not entrusted with the right to declare law as void which are made against the directive principles, but this is not the case in case of fundamental rights. Achieving a political democracy is the aim of directive principles, but Achieving a social and economic democracy is the objective of fundamental rights. Directive principles emphasizes for the well-being of the society, but fundamental rights works for the individual well-being. From a long period of time, there has been a conflicting debate regarding the prominence of directive principles of fundamental rights over one another. The Indian judiciary played an enormous role in solving this issue, where, as in the case of Madras versus Sampakan and Golaknath versus the state of Punjab, fundamental rights got prominence over the directive principles. In the Keshavanandi Bharati case, the directive principles got a higher position over the fundamental rights. But finally, in the Minerva Mill versus the Union of India case, both of them got equally importance in the legal system of India, and it was declared that they are commendatory to each other. The directive principles are criticized on the ground that they are not legally enforceable. Critics also points out that directive principles are not logically and properly categorized and classified. The directive principles are criticized as only some moral guidelines which could be fragmented. Directive principles face criticism because they are considered as conservative in nature, as they reflect the English political philosophy of 19th century. At various points of time, different laws and policies were made by the Indian government which act as evidence of the implementation of some directive principles in real Indian scenario. Acts such as Minimum Wages Act, Employees State Insurance Act, State Duty Act, etc. were passed to implement provisions under Article 39. Above these, many laws were passed to organize Gram Panchayats. Many boards were created by Indian government for the advancement of cottage industries. Under the Article 43, the Community Development Project of 1952 was an initiative of the Indian government to increase the living standard of rural people. Lastly, I would like to say that despite of the fact that directive principles are not justiciable in nature, we cannot consider it as fruitless. They act as the guidelines for the Indian state, as well as it contain the goals and values which our nation endeavors for. It strives to provide Indian population with a good social and economic life. The government can be held accountable by these principles. Thank you for your due patience.